Good morning, everyone. Again, thanks for joining our Saturday knowledge session as usual. And as today's topic is Foreign Contribution Regulation Act, something different, but though vibrant and very much debated. And as on today, it's very much relevant. And in view of CSR, and even though your company is not taking FCRA, you should know this regulation, as you know that if you give any CSR contribution, that institution should be compliant with this FCRA Act, which is very crucial for any institution which is eligible for CSR. So in view of that, it is relevant for all the companies and all the company secretary, whether you yourself are associated with directly with the institution or not, because indirectly it impacting all the companies and all the company secretary and the profession. So this that way is relevant. Our today's guest is something we would like to know introduce is Mr. Ashish Goyal. Mr. Ashish Goyal is a founder managing trustee of Umang Foundation, and I have worked with Japanese investment bank for 12 years. And before that, he worked for the Patni Computers for almost 3 years. He is passionate to serve the less privileged section of society and has started Umang Foundation in 2008 along with two colleagues of Lehman Brothers. Ashish has taken mid-career break in 2019 from the corporate life and have become full-time professional trader. Ashish has himself coordinated or managed to get his NGO register at all fronts, charity, 12A, ATG, FCRA. Great. He is himself involved in all routine filings with the help of professionals of particular section. During this session, he'll be sharing his experience of dealing with FCRA department. Along with that, he will be hosting question answer session for the participants. Oh, great. That will be a great experience for us. So participant, today we have a very active session and very vibrant personality who is in the corporate and in this field as well. So welcome, Mr. Ashish, and I will thanks for your time. I'll just share transfer to request Mr. Bala to say a few words on topic, who is our always moderator. And then Mr. Ashish, I'll request you to say a few words on the topic. Sorry, this today Mr. Jayesh Trivedi is unable to join because his net connectivity is, he has to go to the native place for some reason, and net connectivity there is not available in the place where he is. So he has requested, he will unable to join and he has apologized. So I also apologize on behalf of Mehta and Mehta for that inconvenience to participants. Thank you. Over to Mr. Bala and then Mr. Ashish.
Good morning to all of you. I have a great pleasure in welcoming you all for today's session on my own behalf and also on behalf of Mehta and Mehta. The Foreign Contribution Regulation Act, which was enacted somewhere in the year 1976, has actually undergone various amendments from time to time, and the new act has been replaced in 2010, Foreign Contribution Regulation Act, and recently in 2020, there are far-reaching amendments have been actually made. We'll be thinking, why this foreign contribution regulation being so much? Because we are all watching the TV. In the TV, we see there are various NGOs, they are receiving the money, they are misusing the money for various purposes. Money received is not utilized for the same purposes. Money is actually received, but the purpose for which it is not utilized, transparency is not made, accounts are not submitted. Many times people do not know where the money has actually gone. All the things are all there. So with the intention, the government thought there is a real need to have a stricter regulations. There is nothing prohibiting in receiving the foreign contribution, but it should be received legally and it should be spent for the purpose for which it is actually received. and there should be a periodical transparency disclosures to be made. This is the purpose actually. But now what is happening is, if you are watching the TV, there are a lot of things. Even in Maharashtra also, we had some of the lawyers associations. That means, I think if you all will be remembering, the case was there in Bombay High Court for some time. This was actually a case of Anand Grover and Indra Jaysingh, who were running the NGOs, who are actually renowned lawyers. And there were a lot of allegations have been made, etc., and other things and all. And not only that, the earlier act, once you register, the registration has been given permanent. Then nobody bothers about it. Now the 2020 amendment has brought, once a registration given, it is valid only for the period of 5 years. And before the expiry of 6 months, the renewal is required to be made. And again, the government has actually made a point that if necessary, they will carry out the necessary inspection to find out whether the NGO is actually not in fictitious name, it is actually fulfilling the purposes, it is maintaining the accounts, it is complying with all the requirements. And not only that, it has also come to the notice of the Home Ministry. There are a lot of NGOs unregistered. Nobody knows what is happening, because once you are registered, the compliance comes into the picture. If you are not registered, then the compliance, etc., and all these things is not there. It is very difficult to find out. This is what has happened. Many of you who have been watching on the parliamentary session, whenever the budget is actually being passed, most of the people will be watching the budget, but I do not know how many people are interested in watching the session when the real act is actually being passed. I had an opportunity of watching the parliament when the bill was being passed, amendments in 2020. Earlier, the administrative expenses were granted up to the limit of 50%. The 2020 Act has brought it down from 50% to 20%. There were a lot of discussion and debate was there. The minister simply answered only one thing. I remembered still what was talked in the parliament. He said, if the person is buying a high valued car fitted with 3-4 air conditioners and is using it and charging to the administrative expenses, what really he is actually going to give a society the benefit? This was the question it has been actually asked. In one of the much earlier sessions, it was also there, it was debate actually. It seems somewhere 20,000 crores of money has been received and nobody knows where the 10,000 crores money has gone actually. There are cases. There are a lot of misuses, because in tsunami time, there are a lot of foreign contribution has been received, but purposes partly utilized and major part of the money has been misused. So arrest all the things, the 2020 amendment has brought far-reaching amendments. They actually said very categorically who are the people who should not actually receive money. In this list, if you actually go through it, basically the various political organizations who are actually there, the judges are there, government servants are there, MP, MLAs are there, all these people. Even disclosure is required to be made by the person who is standing for the elections. And plus registration, I already told you, it is not a permanent. It is only for a period of 5 years. The renewal is actually called for. Enquiry provision has been actually brought in. Administrative expenses has been actually reduced. One more important thing is to identify the people. It has been very clearly told, whenever you are registered the NGO, the Aadhaar card of all the office bearers, directors and KMPs are a must. In case of the foreign national, then again, the certificate of the passport is actually required. All the things have been brought. If you actually look at it, government is very much concerned, because basically the foreign contribution money should not be misused, which will affect the sovereignty of the country, which will be utilized for the illegal purposes. Because very recently we have been watching in the TV, there are a lot of funding is happening in the terrorist activities, etc., and all these things through the foreign sources, etc. The government wanted to ensure A, the country's security, B, misuse of the illegal way of the foreign funds which are received, which is ultimately not delivering the thing. That is the purpose. So with this few words, I would like to say this act is very, very important, as Dipti madam puts it, because a lot of compliances where the company secretaries are required to certify various forms, annual returns, quarterly returns, and again, event-based returns, etc., and all these things, we need to be very careful. We may not be involved in the NGOs, but we are involved in certification. We are involved in some of the organizations who are receiving the money. We are involved in some of the organizations. And in fact, if you see, foreign contribution may receive directly from overseas countries. But at the same time, foreign contribution can also be received within India, which has got the branch of the overseas countries. So that is why the transparency actually made it the source, which is to be actually disclosed. What is called local sources and foreign sources. The classification has actually come. If you actually go through the annual return, if you open, if any of the people can go through, even the common man going through the annual return, the reporting sources has been very categorically mentioned, where the certifying authorities, that is basically the professional, has to be very, very careful in this. Accounts will be maintained separately, sources to be declared separately, utilization has to be kept separately, transparency, disclosure are required to be made. All the things are involved. I think Neel has prepared a very good insight of the foreign contribution regulation, taking into consideration various requirements, various compliances, etc. But to be very frank with you, this not only involves the company secretaries, it also involves the various bankers, it also involves organizations themselves, it also involves organizations who are actually funding the things. But in today's session, we may not be able to cover because of the large subject and the paucity of the time, but we will be covering towards understanding the act, requirements, most of the compliance part of it we will understand today. That is what it is. Over to Mr. Ashish, who's actually an expert, who's actually associated with the practical experience of dealing with the NGO, registering, etc. He will actually add a few words before we start. Over to Ashish, please.
Thank you, Mr. Bala. You covered actually really well and summarized everything what I wanted to say. So I will keep it very short. I would like to say a very simple thing, that FCRA is not a complex subject, but lack of knowledge around this subject, and the people who work around this, maybe an NGO or a consultants and the bankers, they do not have adequate information around this subject. So thanks to Mehta and Ms. Dipti that you have organized such a knowledgeable session today. And I'm sure all the people who are participating today will get something as a takeaway and add to their learning and add to their knowledge base as well. Thank you.
Thank you. Neel, you can start.
Good morning, everybody. So the topic for today's presentation is such that it is such a crucial topic because it touches the most sensitive area of our country, that is our national interest, the sovereignty and integrity of India. And that is the reason it requires more stricter and more stringent regulations than any other law. And that is the reason why the central government has came with a lot of crucial amendments and drastic changes were made in the FCRA 2020 Act. So that is that I'm going to cover in this topic. So as Bala sir rightly said, before this FCRA 2010, there was a law called FCRA in way back 1976, which was rather more promoting law and not more defensive or controlling law as compared to the recent FCRA 2010. But with the time changes, government comes to know that it require more stricter regulation because there are some gray areas which is utilized by the NGOs, not for the benefit of the society, rather for their own personal purpose. That is the reason why government has came with this new act, Foreign Contribution Regulation Act 2010. So let's understand the basic object of that. So as the name itself defines its object, the purpose of that is to regulate, to legitimate the foreign contribution and foreign hospitality which is received by individuals and other specified persons. And also it is to prohibit such kind of activities, to look into the activities that is very prejudicial to our country's interest, to the security of the country or a public interest. So mainly it focus on two things. One is foreign contribution that we will discuss what is foreign contribution, and second is foreign hospitality. So before jumping into the main provisions, it is important, essential to understand with some key fundamental definitions in that. So what is foreign contribution? Section 2, subsection 1, clause H of the FCRA defines foreign contribution means donation, delivery, or transfer made by any foreign source of any article, currency, it may be Indian currency or foreign currency, it doesn't matter, or any security as defined in the Security Contract Regulation Act 1956, that is Fcra, and any foreign security also as defined in FEMA. So foreign contribution deals with mainly three things: donation, delivery, transfer. Here important word is made by any foreign source of any article, currency, or security. However, if some foreign source or any foreign citizen delivers some gift to the Indian person for his personal use, and the market value of the gift or article not exceeds 1 lakh rupees on the date of such gift in India, then it will be exempted from the definition of foreign contribution. It was a increase from 1 lakh. Previously, it was a 25,000. So government has amended, increased the threshold of the gift from 25,000 to 1 lakh. So now it is essential to understand what is foreign source. So foreign source means it is a very wide definition, I will say. It covers almost all the foreign citizens, foreign countries, foreign government. So what is the foreign source? First, government of foreign country or territory, any international agency. However, there are some recognized agencies like United Nations, World Trade Organizations, or UNICEF, or International Monetary Fund. If some NGO receives funding from that international agencies, then it is not considered as a foreign source, because it is well recognized agencies. There are lots of transparency in that NGOs, so it will not fall in that foreign source. And government has exempted almost 109 international agencies, mainly the specialized agencies of United Nations, from this category, and it is all on the Fcra website also, so you can check that. Third, corporation incorporated in a foreign country territory, multinational corporations. So multinational corporations which is incorporated in a foreign country territory and which have subsidies or any principal place of business in 2 or more countries. Now, foreign company. It is essential to understand the definition of foreign company here. So foreign company as per FCRA means any company or association or body of individuals, and includes a foreign company as per our Companies Act. It's a subsidy of a foreign company also, whether Indian or foreign, and multinational corporations also. So foreign company definition is a much exhaustive, I will say, because it includes not only the companies but also body of individuals also, and subsidy of foreign companies also. Then trade union of foreign country, that is also covered. Then company as per Companies Act. So any Indian company which is incorporated as per Companies Act, and if a majority control or more than 50% of the nominal share capital is controlled or held by any foreign source, any foreign citizen, then it will come under the foreign source. However, the central government has came with a clarification: if that majority control is held by the foreign citizen, but it is within the limit of FDI, that is, it is not crossing the threshold or the sectoral cap as mentioned, the FDI, foreign direct investment, then it will be exempted from this foreign source definition. So it should be keep in mind. Then foreign foundations, any trust that is controlled directly, indirectly by the foreign government or foreign country. And last but not the least, citizen of foreign country. So a question may arise that some XYZ NGO is receiving fund from NRI, right, or any person of Indian origin. So whether it will be treated as foreign source, foreign contribution or not. So the citizen of foreign country also has defined in the act. So if any non-resident Indian or any Indian passport holder, which is giving or transferring any money from his personal savings, not from any other foreign source, through the normal banking channel, then it will not be treated as foreign source. However, if a person of Indian origin or a OCA holder transfer any money, it will be treated as foreign source because they are not Indian citizens, they are foreign citizens. So this should be keep in mind. Moving forward, the next term is foreign hospitality. So as already said, the Fcra covered two major terms, that is foreign contribution, or it's already discussion. Second is foreign hospitality. So what is foreign hospitality? Any offer made in cash kind by the foreign source for providing a person with a cost of travel to any foreign country territory or any boarding, lodging, transport, medical treatment. This is mainly for the government servants or the people who are employed in the government sector, because they are representing the country, the public. So if they are receiving any foreign hospitality, then there is some regulation that they need to take the prior approval from the ministry, because they may get biased. So following category of person require prior approval from the Ministry of Home Affairs before accepting this foreign contribution. First is member of legislature, MPs, MLS, office bearer of political party, the judiciary, judges, government servants, public servants. So here the public servant has been added in the Fcra 2020 because there was a controversy way back in 2016 that a lawyer was running an NGO and he defines that I'm not falling under the government servant definition, and it was true. That's why government has came with a public servant in this criteria also, because public servant as defined in IPC, and it includes lawyers also. So now any lawyer is running any NGO, then will come under this criteria. And employee of any corporation or other body owned controlled by the government. So here the question may arise that employee of any corporation, say if I'm working under any government sector company like a bail or sale, and I'm going for a foreign trip and receiving any hospitality. So whether I should also need to take prior approval from ministry. So the definition of corporation is defined in FCRA, which says it includes government company also as per Companies Act. So if you're an employee of a government company and you are receiving any foreign hospitality, then you need to take prior approval from ministry. Now foreign hospitality, how to apply? So there is a form called FC2. It's a fully online form. So the applicant need to submit his application in FC2 form. At least the application should reach 2 weeks before the tentative date of journey. And some documents are required, like applicant signature, the invitation letter from that host country, and if the ministry is sponsoring that visit, then also the administrative clearance certificate is required from the concerned ministry. This is all about foreign hospitality. There is a caveat in that which said that suppose I am going to visit any foreign country, and during that visit I'm facing some sudden illness, and so that I require urgent medical treatment, right? So it is obvious that I will not go for the prior approval, because it is the importance of health. So that's why government has keep in mind this and exempted relax from this provision, that if any person while visiting the foreign country and facing some urgent illness and requires medical treatment on an urgent basis, then it can take this medical treatment, and it needs the post intimation to the ministry within 1 month from the receiving foreign hospitality. If the hospitality, the monetary limit is up to 1 lakh, then there is no requirement to intimate the ministry also. So this is the relaxation given by ministry. Now let's come to our main topic, who can receive foreign contribution. There are 4 categories of specified persons in that which are eligible to receive foreign contribution. Any individual can receive. Hindu and family HUF also is eligible. Any association and a Section 8 company that is of the Section 25 companies at 1956 is also eligible to receive foreign contribution. But there are some conditions. The most important criteria is that that NGO should have some activity which is beneficial to the society, say for any cultural activity, economic activity, or any social program the NGO is running for the benefit of society. This is the main criteria. Second, it must have to obtain the registration from the ministry, and it must not be prohibited by the central government under Section 3 that we will discuss. So Section 3, it is the most fundamental section which govern the FCRA. Section 3 says following are the person which are prohibited to accept foreign contribution. So first is the candidate for election. Second are public servant, judges, government servants, employee of corporation owned controlled by government. That is mainly the persons that which were covered under the foreign hospitality. Any politically exposed person, MPs, MLAs, any person working in a newspaper agency like cartoonist or columnist, writer, a political party, definitely they can receive foreign contribution. However, Section 3 prohibits the person from receiving foreign contribution, but Section 4 is overriding Section 3 here. It says that in certain situations, although person who are prohibited under Section 3 can also receive foreign contribution, like any remuneration due from the foreign source, or any salaries or any wages due, or they have some done some import export and some payment is received in the course of a business. Then as agent of foreign source, also they are eligible, but if the transaction with the foreign source with the government, central or state government. So if government is dealing with so many, foreign export or import, like a Rafale deal, and if you are the agent of the foreign source, then you are exempted. Any gift or presentation you have received as a member of Indian delegation and relatives. Yes, government has also relaxed the requirement for this prohibited person. If some government employee or judge is receiving some foreign contribution from the relatives, it is exempted. Now, what is relatives? Relatives is defined under Companies Act. That is the same. However, government has came with some amendment that if the prohibited person are receiving contribution from the relatives exceeding 1 lakh in a one financial year, then they need to intimate the ministry in a specified form FC1 within 30 days. Again, the political party not eligible, organization of political nature, and a newspaper company, news agencies, TV newses, because they represent the public. If some foreign, if they are receiving some foreign source, and if that person is controlling the news agency, then definitely the news agency will get biased, and there are bright chances that the public may be get confused, or there are some misleading news that may be published. That's why the government has included the news agencies, any newspaper agencies, editors, owners in this prohibited category. Moving forward, now there are 2 ways in the FCRA that NGO can apply for the receiving foreign contribution. One is a long-term registration, that is a 5 years time period that you can receive foreign contribution. Another is prior permission. We'll discuss both the routes in details. So first comes Section 12. As already discussed, the 4 category of person can receive foreign contribution: individual, HUF, an association, or a Section 8 company. Now there are some criteria mentioned before applying for the registration. So Section 12 deals with the eligibility criteria for grant of registration. it is recently amended by the government. Before that, there was no such criteria, which you can see now. First of all, it should be registered in any existing statute, maybe Companies Act or Indian Trust Act or any Society Registration Act. Normally, it should be governed by any other law. There is some track record of 3 years. The NGO should have a minimum track record of 3 years for applying for the long-term registration. And in that 3 years, it should have spent at least minimum threshold of 15 lakh during that period of 3 years for the benefit of society, for any cultural or any social activity, religious activity. Then only it can apply for the long-term registration. However, in this 15 lakhs, there is a clarification that if I have some hospital or any school in terms of any capital investment, that any building or any other vehicle, that is included in this spent amount 15 lakh also, but subject to the main person, the chief functionary has to give undertaking declaration that this assets will be utilized only for the purpose for which NGO hold the registration, and it will not be transferred or diverted to any other area until the NGO holds the registration. This undertaking is mandatory. However, there are some administrative expenditure also, which is not counted in this spending of 15 lakh criteria. And what is administrative expense? I have covered in the next slide. Rule 5 defines the administrative expense as under salaries, wages given to the governing body, the directors, any traveling expense, like normal utility bills, gas bill, electricity bill, legal professional charges, any filing or any writing of any expenses. These are some of the admin expense that will not be counted toward the spending of 15 lakhs. However, this is a recent amendment, and due to this, some of the NGOs are engaged in a research or some analytical data. Then before this amendment, there was a cap of 50% that NGO can utilize 50% of the foreign contribution in the admin expense, including research. Now government has reduced this limit from 50 to 20%. So now it is very much difficult for those NGOs who are engaged in research, because 20% is a very less limit that they cannot utilize in the research. So that's why government has relaxed for those NGO which are engaged in research and any other field data. If they are giving any salaries or any remuneration or any wages to the research personnel, then it will not be counted in the admin expense. Another, say some NGO running hospitals or schools, and if they are giving any salary to the doctors of the hospitals or any teachers of the school, because it is in the direct objective of the NGO, it is linked with the direct objective of NGO, then also it is exempted by the ministry from the admin expense. So if you are giving any salary to the teacher of hospital or to the doctors of this doctors of the hospital, then it will not be counted in the admin expense. It should be linked with your main objective. Now there is another mode. If you are not eligible for this long-term registration due to you are just newly incorporated Section 8 company, you have no track record of 3 years, or you have not spent the minimum requirement of 15 lakhs. And there is another mode which allow you to receive foreign contribution, and that is prior permission. But here prior permission is granted only for the specific amount and only from the specific donors for the any project, right, or any a school or any hospital you want to open. So it is only for the specific amount from specific donor for the specific project. So criteria is same. Any NGO or any other person statute. Second is that there is a specific commitment letter required from the donor that this fund will be utilized only for the specific purpose of the project for which the foreign contribution is proposed to be received. This is another way.
Basically, it is a one-time approval from the particular person from whom you are receiving it for the particular purpose.
Yes, sir. Right. So if some NGO is in a very formative stage, It is not mature NGO, just have incorporated a company and required some raising of fund from the outside country, and they can go through this route also. Now, after eligibility criteria, there are some conditions which I will say the NGO should not fall in this condition because it is a negative term. So section 12 says that following shall be the condition for the grant of registration prior permission. So the applicant should not fall under this condition, that it should not be a fictitious benami. It is not indulge in activities that leads to conversion from a religious faith to another. It is not, in short, there should not be any criminal record, right? It is not found guilty for any money laundering or any siphoning of funds. These are the some condition in negative form that the NGO applicant should not fall in this category. That the NGO or any of the directors of the NGO is not convicted or any prosecuted under any law, right, before applying into this. So before granting this registration certificate of prior, the central government will check that the person is not falling under any of these conditions. So second, the acceptance of foreign contribution by the person is not likely to affect. This is the main object of that it should not prejudicially affect our sovereignty integrity of India, our strategic interest of the state, public interest, finance of election. These are, I will say, it is a weapons of government, because these terms have not defined anywhere in any law, not in Fcra and not in General Clauses Act also. So government can use any of these terms and cover your NGO if you are doing some activity which is detrimental to the national interest. So any doubt till here?
No, so far so good. There is no issue at all, because many people would be watching it. What you have said, they can correlate to the various TV news also, because when you said actually the conversion from one religion to the other religion, in fact, people will definitely recall there are two organizations which rocked the national TV on a Kerala issues. I think if I remember correctly, it was some organization called the Good Samaritan Project and the Catholic Reformation. This was actually in the TV news for quite some time. Many people would recall it actually. The whole purpose is that it should not be used for the illegal purposes. It should be used for the right purposes. That is the thing. You are absolutely right. So far, so good. You are doing a good job.
Thank you.
Yeah, go ahead.
Yeah. So
in fact, I can see in the chat box also there are people appreciating your presentation.
Thanks.
Yeah.
So moving forward, after passing these conditions criteria, now it's NGO applies for the registration. So what is the process? What is the SOP? So the two main things here the NGO should keep in mind before applying for registration. One is they should apply register themselves with the Niti Aayog and receive a Darpan ID, that is called, for the NGOs. And second is, before applying for the registration, before making application to the ministry, they should open an FCR account in the only New Delhi branch of State Bank of India. I will cover this. This is a major amendment government has brought in the FCRA 2020 Act. We will discuss in the later slide. So this is the two major requirements before applying for registration. One is a Darpan ID, and second is open SBI account in New Delhi main branch, which is called FCR account. So how to make application? It is very simple. If I am not wrong, in the initial stage there was a physical documents when the act came on the 1st May 2011. But gradually, the ministry has implemented in a phased manner, and now it is fully online. There is no physical documents required to be submitted to the ministry. So first, there is a form for the registration FC3A, and for prior permission FC3B, that need to be filed on the official portal, that is fcraonline.nic.in. Another amendment, or we can say additional document that is required is Aadhaar number is now compulsory for all the directors of the NGO or chief functionary of the NGO and the Darpan ID for the NGO. And if some director is a foreigner, then for them there is a passport or OCI card is also required. Request at least at
Question is
10,000.
appearing on the chat box. If you can actually go through.
Okay.
The question is actually non-profit organizations outside India want to incorporate a private limited company as wholly owned subsidiary and will infuse FDI into.
So your connection was lost. Hello. Hello. Mr. Bala. So I think Mr. Bala has lost his connection. Hello. Am I audible, ma'am?
Yes, Neel, you are audible. Whereas Mr. Bala is the, I think he has.
Yeah,
he's back.
I think he has lost his connection. Okay, no worries. So moving forward, application for Fcra registration. So there is a simple form FC3A for registration and prior permission FC3B. The fees are to be submitted only through payment gateway system. No checks and demand draft are accepted. Before the amendment, there is an option that you can pay through check demand draft also. But to the recent amendment in 2020, there is only option through payment gateway. So the documents required are very simple. The chief function is signature. Then your incorporation document, certificate of incorporation or trust deed, your MOA, the main constitutional documents, the activity report of the NGO during the last 3 years, what the activities has been done for the benefit of society, and with highlighting that the what are the activities in which the amount of 15 lakh, that is a minimum threshold, has been spent. Along with that, audited statement of accounts for the past 3 years also required, including income, expenditure, assessed liability statements also. These are the major documents required for long-term registration. For prior permission, as the company is in a formative state, so there is no such balance sheet and track record of 3 years. So there is very lesser forms required. Again, same chief functional signature is required. The constitutional documents, certificate of incorporation, trust deed. One additional document is required is a commitment letter from the donor. That is undertaking that the proposed foreign contribution will be utilized only for the activities for which foreign contribution is received, for the specific purpose, for the specific project. And along with that, a project report is also required. That is defining the projection that in the future, what are the activities in which the foreign contribution is proposed to be utilized. Some are the basic details which need to be filled in the form. First is PAN and Darpan ID is mandatory of the NGO. Then details of the Fcra account. As already discussed, so before applying for the registration or prior permission, you need to open a Fcra account, designated Fcra account in the SBI branch of New Delhi. Registration details under relevant act, any societies like Indian Trust Act, Companies Act. The expenditure income in the last 3 years towards the activities. Then what is your core object for the society, economic, cultural, religious, Then Aadhaar number is compulsory for all the directors of the company, and PAN card is also required. And as already said, that if director is a foreigner, then for them a passport or OCI card is required. These are the basic documents need to be submitted along with the application. Now come with section 17.
Ashish, how long it will take to get the registration done?
Sir, once we apply for the registration, the ministry takes generally 90 days. Ordinarily it will take 90 days for a grantee certificate. If you can track the status through your email ID also in the portal also, that is also available. But if there is no such dim approval, if you
No, I'm not saying. I'm only trying to find out how long the process take place to get the final approval, whether it is 2 months, 3 months, 4 months,
Yes,
whatever it is. That
3
is what
months.
I'm asking.
Yes,
Yeah.
3 months.
3 months. Okay.
Then section 17. It is the major section which governs or the whole Fcra. Once the NGO get registered under the ministry, now it's time to accept the foreign contribution, how to utilize, how to transfer this. This is the deal by this section 17. And this section has been replaced wholly with the amendment came under the Fcra 2020 on September 20. So section 17 deals with acceptance and utilization of foreign contribution. So foreign contribution should be received only in a single account, in a one single account, exclusive account of that is called Fcra account at SBI branch, main branch of New Delhi. Before this amendment, there was no such requirement that NGO should open Fcra account in SBI New Delhi. I think the intention behind this change is that the government want to easily track the funding. They can centrally track the record of the what other foreign contribution the NGOs received.
But I think that has created a lot of issue. And,
Yeah, in fact, there were cases which was actually filed that it is affecting the fundamental right of the people
right,
to open an account anywhere and everywhere.
One of the case of opportunity of heard is also covered by Neel later on. But
Correct.
I think one bank only, and literally we were giving assignment that please open the bank account at the earliest. That kind of assignment was coming. So it was, and I think our panelists can rather you put more view on this point.
Ashish has actually got a practical experience on this.
Mr. Ashish, your view and experience on this.
So well, my account has been opened in 20 days after submitting all the papers, and the process and the entire interaction with SBI before opening an account was obviously not so easy and comfy. But yes, I took a help from the local branch and who were coordinating on my behalf. So even the Fcra branch in New Delhi also suggests that you please submit all the papers to the nearest branch, get it reviewed, and send us a scan copy. So once they have sent the scan copy after approving that yes, we have checked all account opening formalities are completed, then it will not take much time because their hassle has been reduced. The Fcra branch hassle has been reduced. So that's how I have used it in my case.
Okay, thank you. Yeah, Neel, go ahead.
Yeah. So as sir truly said, because there are some very major difficulties faced by the existing NGOs. Government has also relaxed the requirement. They have given lots of extension also.
Any participants are here from the banker side? If any participants is there from the banker side, I think we may like to hear from them on this. Anybody there from the banker side here in these participants?
I think
Please.
no.
Yeah.
I think.
You can go ahead.
People who have confirmed me, Mr. Professor Bala, people who have confirmed me from a banking side haven't joined that.
Okay, go ahead, Neel.
Yeah. So the first utmost requirement is you have to open your designated Fcra account in SBI branch of New Delhi before applying for registration. And this is an exclusive account in which you can only receive your foreign contribution. You cannot utilize from this bank account. So for utilization, you need to open another account that is not required to be only in SBI branch of New Delhi. You can open in any scheduled bank of your choice, which is connected with the PMFS integrated facility. There is no such restriction on opening utilization account. But the criteria is that first you should open a Fcra account for receiving your foreign contribution in New Delhi. You can also open another Fcra account for receiving the funds or for transferring from that New Delhi SBI branch to your scheduled bank, which is nearest to your city. And then you can open any utilization accounts for utilizing the foreign contribution.
Actually, there is a question as asked by a participant in the chat box. If a non-profit organization on outside India wants to incorporate a private limited company, a wholly owned subsidiary, and infuse FDI into the company in India, whether FCRA will be required? That is a question number 1. Following that, further, this private limited company will invest CSR in profits in the India.
So, sir, as I already discussed, if there is a major control is from the foreign investor or foreign citizen, then the Indian company is also covered under foreign source. However, if the limit is up to the sector cap as per FDI policy, then it will not be treated as foreign source.
That you said in the beginning. So
Yes.
that means so long as up to the sectoral gap is there, it will not attract.
Yes,
If it is exceeding the sectoral gap, it will attract.
Correct.
Okay.
So the another major amendment that came is in section 7. There were lots of debate and petitions filed in Supreme Court also.
Neel, I have a question on the Professor Bala just mentioned on the question which Pooja Prakash has put in a chat box. A non-profit organization starting a private limited company. The structure itself is,
I was also coming to whether if in India, non-profit organization can set up a subsidiary in India. If that is there, then overseas company. The first question that setting up of a subsidiary company, the
because non-profit cannot do a business across the globe by the structure of non-profit.
Correct.
But in this case, that non-profit organization is located out of India, so they are governed by their law. But the issue we have to check whether non-profit organization.
Ma'am, here are the 2 points. The organization which is outside India is termed as a non-profit. Okay, and they are investing in a company which will do the profits, and the profit will be invested in CSR. Okay, so the structure is not in line. This is my 2 cents.
No, but according to me, that non-profit organization, though we generally say non-profit organization, but it always make profit. Only the profit is not distributed as among the
Dividend.
That is the point. So this is okay. So what the structure is telling, they are using for CSR or their own purpose. That is but the thing that this structure itself is, you are telling, is complicated, it requires certain study. At present, often on the structure we cannot comment, but as regards your question of contribution, that Neel has answered till FDI, that industry, FDI permission is there, there is no abstract required. You are right. Even I don't know if any participant would like to comment on this structure.
I think we can take that
Okay,
offline in case Pooja Prakash needs it more clarity on this subject.
Sure, sir. If I can get any contact details, maybe I can write directly.
Sure. Miss Dipti can share the contact details of the license for anybody. We can have a discussion on that.
Oh, sure. Thank you.
Neel, you want to take questions now because there are a few more questions.
Yeah, sure, sir. Sure.
Mr. Ashish, you can discuss here also, no issue. We are here for discussion.
Yeah.
Okay.
It is for the benefit of everyone.
So in my opinion, for to answer the question of Pooja, in my opinion, as far as I have gone through the charity structure, and because before getting into FCRA, that organization needs to get into a charity structure. Okay, and they will not get approval on the charity structure first, because they are trying to do the funding, or they do not have a standing here in terms of what they intend to do after that. But जो उनका सोर्स ऑफ फंड्स है ना, उस पे ही बहुत बड़ा क्वेश्चन है, क्योंकि ये दोनों चीजें ना दो डिफरेंट एलिमेंट्स हैं जिसको आप एक साथ लेके आने की कोशिश कर रहे हो. One can be a result of the first one, but cannot be a reverse way.
Okay. Okay.
And
So,
well, basically what you want to achieve, because you are setting up subsidiary and then utilize the profit for CSR. So rather than an NPO, that non-profit organization, can set up a branch and do that a non-profit organization activity. Why?
yeah, actually, sorry to interrupt, ma'am. Yeah, actually, they just, want to make it, I'll say, make it on a faster pace, because FCRA registration is a time-taking thing. So they are like, okay, we'll go with the private limited company to mitigate the FCRA requirement at this point of time.
No. But in that
You
case,
cannot go round and round with the laws. It will put you on a court actually.
No, don't do that. That's why only I was confused. The purpose, no, don't do. This is not the right way. It will be
Okay.
questionable.
Okay.
There is a FAQs
Okay, next
also
question
in
is-
the
okay.
FCRA. Yeah, ma'am, there is a FAQ in the FCRA site which says that if I have registered myself as an NGO, and if the foreign contribution I'm going to receive, I am putting or investing in some startup or tech company, and whatever the profit that the startup can generate, then I will donate this profits to the my CSR activity or to the specified to the benefit society. So this is not possible. You cannot indirectly through the round trip do this funding. You need to have a specific purpose for the benefit of society in terms of social or religious or whatever.
And before that, because any FCRA compliant organization has to definitely file returns in as per our domestic rules under ITR. So that will also not allow you to invest in the company which has a risk involved, and startups has a risk involved. So even if you do investments from a NGO side, there are certain rules which you need to comply before you even invest in a mutual funds.
Correct.
Yeah, there are certain category of mutual funds which are risk-free debt funds only where you can invest. You cannot invest in equity-linked funds. So startups is a highly risk element.
So very truly said. Also, in FCRA, there is a term that you cannot invest in speculative investments.
Exactly.
Yeah. And what is speculative investment? So any investment that is connected with the market forces. Maybe it is mutual fund or shares, or maybe in future it will be cryptocurrencies also. So that is banned. NGO cannot invest in that mutual fund or any investment. That is highly risky. But you can invest in non-debt secure funds, NCDs, which are secure. That is possible. That is allowed under the FCRA, but you cannot invest in any activity that is highly risky, like share market.
Correct. That's correct.
There is another question also. It's practical about SBI opening.
Yeah. I'm taking up that.
Yeah, please.
So Ms. Namita is asking, SBI asked for some undertaking which we sent through registered post. They sent acknowledgement through email, but we haven't received any update after that. 2 months elapsed. We are not aware about the status of our application. No response. And from either bank or MHA. What to do? Ma'am, first of all, MHA has nothing to do with this. Second, have you sent this in a 500 rupees stamp paper? This is the one which you're talking about, the recent ask from SBI. Is that one, Namita? Namita, are you there? Can you please unmute? Can somebody unmute Namita?
Can unmute herself. Namita, can you do that?
Yeah, she can unmute herself.
Yeah. I think we can take it later otherwise.
Okay, fine.
Yeah, hello, am I audible?
Fine.
Yeah.
Yeah, Namita, please.
Yeah, we have sent on 500 stamp paper.
Okay.
Yeah, and
तो आपने लोकल ब्रांच से आपकी जो भी लोकल नियर बाय ब्रांच है एसबीआई की, वहां पे आपने वैलिडेट करवा लिया था
हाँ
document को?
हाँ यस डॉक्यूमेंट वैलिडेट करवा के, और ये सब होने के बाद उनका रिक्वायरमेंट आया, दे सेड कि वन अंडरटेकिंग इज रिक्वायर्ड
Yeah.
अबाउट दैट पर्पस एंड ऑल.
FEMA
we will be-
declaration था
हाँ
वो.
FEMA declaration, yeah.
Correct. So,
So
ma'am,
that-
you are lucky that you have got the acknowledgement.
Yeah, okay.
I'm yet to get the acknowledgement as well.
Oh, acha, okay. And we have sent reminder for the updates also through email, from which email they had sent acknowledgement,
Yeah.
but no response we have received.
Yeah. I'm on the same bench with you.
Okay. So it takes time.
Not sure. They have taken it. They don't
Okay.
have a manpower to reply.
So
You-
until and unless they gives us go ahead, we cannot accept foreign
No, nothing
contribution.
like that. It's an additional document they have taken.
Oh,
So
acha.
whatever is for your receiving FCRA, they have already taken from you while opening the account. This is an additional declaration, FEMA declaration, which they have taken, and consider it as an additional document, nothing else, nothing beyond that. It doesn't stop you to receive the foreign contribution.
But from where could we get to that certificate of registration, FCRA registration? MHA will give us, no?
नहीं, वो तो आपको MHA देगा. Certificate of registration is a different thing.
So that has nothing to do with this SBI.
No, SBI is only for the account opening purposes, FCRA account opening purposes.
Okay.
आपका approval तो when you apply for the Darpan portal, when you seek the FCRA registration, you will get it from there, na?
Okay. So
Because
online
there are
we'll
two
have to
different
check.
aspects actually. You know, in fact, you can track your application on the online.
Yeah. Okay.
Yeah.
Namita, I have a question for you.
Yes, sir.
Have you got registration done?
No, that is not clear, because MHA, all the requirements we have complied online,
Okay.
and our application is still under process.
Okay.
And in the meantime, SBI asked this undertaking.
Okay. I got you. So I need to correct my response, what I gave you earlier, because I understood that your organization is already registered. Okay. So SBI is a different entity who's managing your account.
Okay.
Bank account, your receiving account.
Yeah.
And MHA is going to give you the registration.
Okay.
As Neel mentioned just before few slides, that before going to MHA for registration, you have to open an account.
Yeah.
So
Yeah.
you have done the opening of account with SBI.
Yes.
Now you are with MHA for registration.
Yes.
So SBI ने जो भी requirements भेजी हैं, it's a common email which has gone to 10,000 NGOs.
Okay.
Okay. So आपका जो मैंने आपको statement दिया, you can receive the foreign funding. I'm sorry, you cannot receive the foreign funding until you receive the MHA certificate.
Right. Oh, so that we have not received yet.
Yes. I'm sorry, I could not gather that.
No, it's okay. It was not clear from my query.
Yes.
Yeah. If you don't have the FCRA registration, you cannot receive the foreign contribution. That is very clear.
So how long it takes, sir, normally?
That's what Ashish Neel answered. No, it normally takes about 3 to 4 months.
Yeah.
For getting the
Okay.
registration.
Generally
Okay.
it takes 90 days, but in practical scenario, it may
And
take
again, if you are
4 to
having
5 months.
more branches, etc., and other things and all, depending upon the case, it may take a more time also, but generally it is 3 to 4 months, if I understand correctly.
आपका
Because they are not
state
raising
CBI का-
any.
नमिता जी, आपका
They are
state
not-
CID का inquiry हो गया क्या?
They are not raising any further queries also. All the queries we have met, we have provided with the other queries also. And since 2 months, we have not heard from them about any
But
further
have
queries
you checked
also.
with the tracking record? Because there is a track mode is available.
Yes.
what
That
is-
that always says it is in under process.
I see.
Your application is under process.
Ma'am, I think they are checking, they are inquiring from their side, and they will
Okay,
respond
okay.
tentatively in 3 to 4 months.
Oh,
नमिता जी,
Probably you
that's
might
why I
wait
asked
for some
नील
time.
के क्वेश्चन ने जो नील ने जो क्वेश्चन किया उसी के ऊपर पूछ रहा हूँ, आपका स्टेट CID का इंक्वायरी हो गया क्या?
sorry, I didn't follow.
आपका स्टेट CID का इंक्वायरी हो गया क्या?
नहीं, ऐसा कुछ तो भी नहीं हुआ है.
हाँ, तो that will also happen.
Okay.
they will, you know, somebody from a state CID office will come and visit your office and will.
Acha, that inspection has been done. Yes, yes, that inspection has been done.
So that inspection from MHA or state CID?
MHA.
हाँ, तो state CID का भी pending है आपको फिर.
Acha, acha. Oh. A lot of formalities.
नहीं, obviously this has to be tightened up as well.
Yeah, yeah.
Ma'am, once this inquiry completes, the report has been forwarded to the ministry, then your status may get clear. So it is a timely process.
I'll put
Thank
that
you very much.
If for IPO you prepare so much and that money you give return, here you are taking public money and no return. So government is taking extra care.
Actually, yeah, you're right.
Hello.
Yeah, go ahead.
Hello. Good morning to one and all present here and Goyal chat. I wanted to raise a question that I have various Section 8 companies. So I wanted to ask that whether donation, I know that donation taken by a Section 8 company has to be governed under Fcra, foreign donation, right? But if I take any kind of subscription to the share capital as per the FDI norms, so whether I have to take Fcra registration or
Sir, I have already answered this. If you are, taking money in the form of subscription within your sector cap, there is a, different sector cap, 49%, 74% in FDI. If within that limit you are receiving money from foreign investors, there is no issue. You can definitely receive this. But above this limit you are crossing, then you need to apply for this FCRA.
even for Section 8, there is no specific any other.
No, sir. No, sir.
Okay. Thank you, Neel. It was
The only governing regulation is sectoral gap. That's all.
only the sectoral cap has to be taken into it.
Yeah, and if you are raising money under automatic route, then there is no issue. But if you are going for the approval route, government route,
Yes, all those things which I have to regulate as per the non-debt instrument rules 2019, that I will have to follow.
Mr. Ashish, in chat box, 2 more questions if you can take.
Okay, thank you.
Shall I read
I'm just
out?
waiting for the computer discussion. So yes. So Mr. Shrikant Bhosekar has asked, please give comments on original registration was deemed seized in 2016 and now trust is required to get new registration. This process is taking a lot of time. MHA is just holding the final registration. You, Mr. Shrikant, you have just one option: wait, and wait, and you can do a follow-up. Nothing beyond a person can do. Or alternatively, it's too much time or many months have taken. Ask somebody to visit the MHA personally.
It is actually taking months and months. It is more than 1 year. We have complied all the requirement. Everything is done.
No, you have to ask somebody to visit the MHA in Delhi personally and ask the officials there what is the status, because there might be certain things that they have put it on hold and they are waiting for somebody to personally visit and understand the issue. There might be some, seizures जो आपका पहले seized हुआ रहेगा उसका कुछ gross error रहेगा, कुछ penalties रहेंगी या कुछ there must be some.
ऐसा कुछ भी नहीं है. That is already everything is in order actually. All the returns and whatever yearly returns, accounts, everything is up to date filed. Only thing it was, in fact, it is very saddening to know that when the original registrations were deemed to be cancelled, they have never bothered to inform the trusts and NGOs. And I think that is where the people are suffering. And they have been asked to, do re-registrations. So that is what is the hold up now. But that is what it is the situation now.
I can understand the
Just
pain.
waiting now.
Yeah, I can understand the pain, but the best part is you ask somebody to visit the office directly.
But are the visits are allowed, especially in the pandemic?
You have to check. I cannot comment on those things because those are beyond my control as well, or my understanding as well. Yeah. But if nothing is happening, then the only option is you have to ask personally where the file is.
Yeah, file is sending, file is saying, status is showing you have submitted all the necessary clarification. That's all. Nothing more. Waiting for final approval. That is what the status for 1 year now.
Right.
And they keep on
I think
raising
that's why
small, small
better you send the person and check, because from your angle it is up to date, from office angle it may not be.
No, but
That's the only
then
answer.
they would have definitely raised a query, this is not.
Yeah, but that is the
also
only
there.
thing. Now in this, what answer we can give? It can be that if
No,
you
I just wanted to know whether this is the same case with so many other cases, especially where the
always exception
new
is there.
seizing has
No?
happened.
Always exception is there.
Yeah, the point is, the situation is slightly different. We are discussing here about the new registration, but there are earlier registrations which got seized because of the change in amendment in the act, correct? And that situation has put us into trouble. Now, there was no mail or any information to do need de novo. And many so many trust people do not know that it was required. And that has slightly created a gap. That is why people are suffering. I feel so. I mean, you can give your comments.
Okay. Thank
Maybe, anyway, we'll have to wait. That's all. Okay.
Okay, thank you.
Thank
Next
you. Thank you, Ashish. Thank you.
Yeah, nothing beyond can be done actually.
Yeah, okay.
Okay.
We'll wait.
The next question is from Ms. Vanita Patil. Trust received donation in foreign currency during pandemic period, but trust is not registered under FCRA. Now, how to regularize such non-compliance, which provision have to be referred, and can we go for compounding? So, Ms. Vanita, are you there? Can you please unmute? Ms. Vanita, are you there? So, for the interest of everyone, this regulation speaks about contribution, not currency. I, being in India, can donate in US dollars, and still this contribution will be considered local funds. Okay. So you have to see the source. And as Neel mentioned in his presentation, you have to categorize source as your primary person who is giving, or organization who is giving you your foreign currency. So Ms. Vanita, if you are there, just connect back with us. We'll explain it more in detail. How to intimate MHA for closure of utilization bank account? FC6C form does not provide for such closure intimation. Is there any process? There should be a form. Neel, do we have anything specific mentioned in the law for this?
So for a closure, there is no such specific form, but for a change of bank account, there is a form called FC6D that you need to intimate.
Yes.
So I think that is the same form. You can go for a closing of bank account.
So Ms. Darshika, is that answer your question? If you're there, please unmute.
But the closure, it does not show what is to be informed to MHA, because they don't ask for closure date or anything to be filled in FC6C form.
You can also write an email to them.
FC forms which shows for closure, how to mention them, like where to mention.
See what you can do, Darshika. You can also write them an email. There's an email available on the website of FCRA MHA. You can write it to director or a support team and mention that you have filled the FC6 form.
Okay.
You will get the reply. I think they reply in 2 to 3 days. So okay, you can do that. Else you can also give them a phone call. There's a phone line available, and they do response on the phone calls as well.
Okay.
It might happen that you may have to call multiple times because they may be unavailable at a particular moment, but they do reply.
But have you come across the cases where people have closed those utilization accounts and opened a new one or something like that?
So fortunately, I am yet not to. कभी मेरे को ऐसा चांस नहीं पड़ा कि मैं मेरा अकाउंट क्लोज करूं अभी तक तो.
Okay.
So I have no personal experience, but yes, by law it works out.
I think probably you'll have to send an email only. That is what it is required.
Okay.
But the only thing is, I do not know. Normally, all these sites has got a support email, and here also I think I have seen in that site there is something like support FCRA at government.in or something like that. It is there. You may actually use that, and you can check up with them also. In addition to sending the email, you can seek them. This is what I have done. Anything else can be done. You can ask. You'll definitely get the reply.
Okay, okay. Thank you. Thank you so much.
Yeah, ma'am, you can visit the official website. You will definitely get some help. There is a help desk.
Yeah. Mr. Ashish, next question is little bit long, but it basically says that cryptocurrency and that public wallet, and in that if the money is received, how to stop it?
You should not attach your NGO account in crypto or wallets. As simple as that.
Right. Okay. I have
If you
made it
expose
clear.
yourself, it will be. So just for your information, I have not attached my NGO's account even to a Paytm
Uh-huh.
or
Right.
not to a UPI, you know. So
Okay. Then
so
next,
all these $500 million all are frauds. So please stay away. I have got emails in the past stating we will give you 100 crores. My van will be standing on the other side of the road. You will give me a kickback of 80 crores. You will give me a keys of when my officer will check this. You know, such explicit things have been written on email and have been sent to me. And if you say no on the phone call, they even abuse you. I have had such experiences. कि भाई तू नौकर है, तेरे बॉस से बात करवा, तेरे को समझ में नहीं आता सॉफ्ट कोड क्या होता है. Such statements have been given to me on phone calls.
oh,
So all these experience, all these guys are goons. You should stay away of any such transactions. जितना crystal clear आप रखेंगे, उतना crystal clear आपकी organization रहेगी.
right.
और ये खून है, एक बार आपने चख लिया तो आपको फिर आदत पड़ जाएगी. So you better stay. नहीं मैम, देखिए होता क्या है ना कि जब आप मिस अप्रोप्रिएशन करने में आ जाते हैं ना, तो आपने एक खून किया या 100 खून किया, सबकी सजा एक ही है. So better stay away.
Yeah.
Right.
So, next question, Sharia money received in NGO from foreign country, it will treated in Sharia. What it is? Okay, somebody has asked it.
Sharia law and FCRA are different things. You should not mix it. And normally NGOs and the organization do one common mistakes and then they regret for their mistakes. They start one project and they are putting money from domestic funding, and they put money from the foreign currency as well, foreign contribution as well. And then they find it difficult to segregate when the reporting comes in picture. So it is better if you are starting any project from FCRA account or FCRA funding, keep it entirely in that, including its administrative expenses. And if you're doing anything from a domestic account or domestic funding, do it from that. Don't mix two funding. It will be a big gross issues for you to report. Next is we have matured trust. Mr. Satish Bhanushali. Sir, we have matured trust and we want to take foreign contribution one time. Can I apply for prior permission or I have to make an application for FCRA registration? Mr. Satish, are you there? If you can unmute, please.
Yes, sir.
Okay. So, Mr. Satish, why do you want to take it one time? Because the process of one time and the registration is almost the same.
Okay, we don't know whether we will get a contribution on a recurring basis. So that time, this time we are thinking that we can take up for one time, and if I'm taking through the prior permission, so I can avoid FCRA registration. Or if there is no route, then I have to go for registration. Then we can proceed for FCRA registration.
Sir, okay. So I would strongly suggest you go for the registration rather than a one-time prior permission, because the process is same, number one, and the filing and the compliance is not too hard. आप यदि TDS filing कर रहे हैं, आप यदि मतलब it is easier than the TDS filing.
Okay.
When the filing comes in picture. So,
okay. So I was thinking if there is a easier route to take a one time and take the funds, and if both are process same, then
zero funding भी apply कर सकते हैं ना, मतलब quarterly returns आपको file करने पड़ेंगे और आपका यदि funding नहीं भी आ रहा है तो आप zero funding file करते हैं.
nil return file करना पड़ेगा.
Nil return file करना पड़ेगा. Yes, yes.
Okay, sir. Thank you, sir.
And sir, if you, I will also suggest go for the long-term registration, because in prior permission, what happens? There is a condition that if you are receiving fund for more than 1 crore rupees, 1 CR, then what the government is doing right now, if you are releasing some installments, some tranches, right? So government will not realize the second installment, second tranche, unless you have utilized almost 75% of the previous installment. So the your funding in the installment will get blocked until you utilize 75% of the previous installment in prior approved route. So I will suggest you go for the long-term registration, because compliance part is the same in both the routes.
Okay, sir. Thank you so much, sir.
So what is the process of annual return compound? Can we get a copy of presentation, Sudarshan? So that's up to Neel and Miss Mehta. आप decide कीजिए वो point.
Yeah, every participant will get it, don't worry. We'll mail it, every participant.
So I was talking to another lady, so I just posted the email ID of the director of Fcra. So you can write it on this email ID. They will respond in few days. Next is Mr. Sanket Londe. He's asking what is the process of our annual return compounding. Neel, I think you have to take compounding word. I can explain about annual returns, but what is annual return compounding?
Sir, for compounding also, there is a simple process you need to apply in a that is a prescribed form. There is some requisite fees also, 1 to 5,000 you have to pay with the application, and then you can go for compounding. Generally the ministry, the secretary of the Ministry of Home Affairs receive this compounding application, and then they delegate to their team.
Mr. Sanket, is that answer your question? If you're there, please unmute.
Hello.
Yes, Mr. Sanket.
Hello.
Yes, please.
Yes, Sanket.
Sanketji, I think you don't have a proper connectivity. So if you come in a proper range, please connect back. Moving to next question, Mr. Nitin. Yeah, Mr. Sanket.
Yes, sir. मुझे जो अभी एप्लीकेशन फाइल करना पड़ता है वो प्लेन पेपर एप्लीकेशन सबमिट करना पड़ेगा या उसके लिए कोई फॉर्म वगैरह है उसका?
You mentioned specific form is there for compounding.
Sorry.
He is asking any specific form for compounding is there or a simple application?
No, there is a specified form.
Number you can give it later, whatever form, but there is a specific format, not a simple application.
Yes.
Okay. Okay, Mr. Nitin, we will write to you separately for that form number. Okay?
No, that was Mr. Sanket. Nitin is next.
Oh, sorry. Sanket.
Mr. Nitin Alok Akolkar, are you there? Please unmute.
Yes, I am there.
Any prior approval of RBI is required for opening of a bank account of trust with SBI. So the first question is, there is no prior approval required from RBI. You can open an account in SBI if you are intending to apply for the FCRA registration. Okay. The account will be in a freeze state until you see the FCRA registration, and the copy you have to provide to SBI. And after acknowledgement from SBI, you can start receiving your funds in the SBI account. And the third part of your question is where the settler of trust is NRI. So when you will apply for the registration, it all will be covered within that. So if MHA approves NRI as a settler, that is good enough. If doesn't, then anyway you don't have a registration. Nitin, is that answer the question?
Yes.
Okay.
Thank you.
The last question for now is Miss Nimita. Can you unmute yourself, Miss Nimita Suvagya? Registered trust receiving money in rupees from NRE account needs FCRA registration. Okay. So I understand NRE still have an Indian passport, and the whole thing comes over there itself. If an individual is having an Indian passport, it is considered as domestic fund. and you don't need a FCRA registration to receive the funding.
Okay, sir. Yes, sir. The
But sir, it is
NRE is having the Indian passport. Actually, there was an old trust, and they were utilizing the funds from NRE account. That trust was not registered, and some conspiracies were there. And what happened is the trust resigned. New trustees came in, and they formed a new trust. Okay, with the same purpose and with the same objective, a new trust was formed. Okay, the funds are coming from the same source, the NRE account of the
That
same
doesn't
person.
make
who is
difference, ma'am.
holding the Indian
So
passport.
when the charity structure has been changed from, say, registration number 1 to registration number 10, okay, so it's a two different entities, no matter the
No,
source.
sir, the charity purpose has not changed.
Doesn't make
The
difference.
funds has not changed. No, sir.
Doesn't make difference. आप
Okay.
बात कर रहे हैं मुझसे, एक रिलायंस इंडस्ट्री है जो चैरिटी ऑर्गेनाइजेशन है, टू अंडरस्टैंड, या गिव इंडिया है, और एक आपके सामने सपोज उमंग फाउंडेशन है, ठीक है, तो दीज आर टू डिफरेंट ट्रस्ट, इनके ट्रस्टी सेम हो सकते हैं, इनका ऑब्जेक्टिव सेम हो सकता है.
Okay, sir.
Okay, so whether Give India can receive the fund or Umang Foundation has been receiving a fund doesn't make difference. These are two different entities.
from where is
Okay.
the fund are receiving, ma'am, that is the important. If you are receiving from NRI, and if he's giving from his personal savings or not from the other sources or from any foreign government, then it is not required to go for the registration. It is exempt.
And I tell you where you find a hiccup. The bank in which it is getting credited. Okay.
Okay.
Bank in which it is getting credited, it will ask the passport of the person who is transferring this amount.
Yes, sir.
Okay, they will take a passport copy. So in my experience, SBI didn't ask for that.
Sir, actually, the NRE account is in Bank of Baroda.
Okay,
Okay, the NRI is having the Indian passport.
correct.
And the registered trust, as I told you, let's forget about the old trust. The new registered trust is
Yep.
having an account in HDFC Bank.
Perfect, no issues.
So receiving money from Bank of Baroda NRE account from our HDFC Bank, we can use that money for our purpose. Do we need to register under FCRA?
No,
madam, that's
because
what
it
I
is a
just said.
domestic receipt. It is not
Okay.
a foreign contribution.
Okay, thank you.
What you are
sir.
receiving is a
taking-
domestic receipt, na?
Okay, sir. Okay, sir. Okay.
Miss
Actually, there
Nimita,
was a lot of confusion in this, and we were consulted several.
no, Miss Namita, it's not a confused. आप देखिए इसमें दो तीन चीजों को बहुत linearly और simple तरीके से समझिए.
हाँ,
आपका डोनर जो है उसके पास
हाँ.
इंडियन पासपोर्ट है या नहीं है, पहली
है.
चीज.
Right.
आई एम जस्ट आस्किंग यू फॉर द फ्यूचर कोर्सेज. ओके,
Okay. Yeah.
आपको कोई भी फॉर ऑल द पार्टिसिपेंट्स एज वेल, व्हेन यू टॉक अबाउट द फॉरेन सोर्स, आपका फॉरेन सोर्स यदि कोई इंडिविजुअल पर्सन है तो उसका पासपोर्ट पूछिए केवल. यू नीड नॉट टू गेट इनटू एनी अदर डिटेल. पासपोर्ट यदि नॉन इंडियन है तो आप दिमाग लगाइए मत ही, वो आपका फॉरेन सोर्स ही है, उसके अलावा कोई चॉइस ही नहीं है. और यदि उस पर्सन के पास में, डोनर के पास में इंडियन पासपोर्ट है तो वो डोमेस्टिक फंड ही है, उसमें कोई आपका सेकंड थॉट ही नहीं है उसके अंदर. ठीक है,
Even
दिस इज
if-
वेरी क्लियर
even-
फॉर द इंडिविजुअल्स.
Even if he is receiving that money from foreign.
एब्सोल्युटली यस.
Okay. Okay.
आपको एग्जांपल देता हूं. आपका ट्रस्ट है एग्जांपल XYZ, ओके, एंड आशीष गोयल हैविंग इंडियन पासपोर्ट,
Okay.
staying in New York, donating from Bank of America account based in New York branch in US dollars is still a Indian domestic donation.
Okay, sir. Okay.
ये बहुत क्लियर रखिए. अब यहाँ पे गलती क्या करते हैं ट्रस्ट, मालूम क्या? जब रिपोर्टिंग करने जाते हैं ना, तो मैंने आपको सपोज मान लिया $2000 भेजे, तो मैं रिपोर्टिंग करता हूँ $2000 की. ये बहुत बड़ी गलती होती है, कॉमन मिस्टेक सही है. आपको क्या मेंशन करना है मालूम? आपके बैंक अकाउंट में, जो आपके इंडियन ट्रस्ट के बैंक अकाउंट में जो अमाउंट क्रेडिट हो रहा है, सपोज मेरा रेट का ट्रांजेक्शन हुआ 80 रुपए से, 80 रुपए से मैंने $2000 आपको भेजे, 1,60,000 रुपए लेकिन ट्रस्ट को ट्रांजैक्शन चार्जेस लगा, ट्रस्ट को ऐसा लगा वैसा लगा, कुछ ट्रांसफर में और चार्जेस कट गए, आर्बिट्राज हो गया, कुछ भी हो गया, और मुझे आया केवल 1,54,000 रुपए, या मुझे आया 1,64,000 रुपए। तो जो अमाउंट आने पाई में मेरे अकाउंट में क्रेडिट हो रहा है, मुझे वो अकाउंट में वो अमाउंट का ही मेंशन करना है FCRA डिपार्टमेंट।
राइट सर।
मुझे उसका डॉलर्स में जाके ट्रांजेक्शन दिखाना ही नहीं है, क्योंकि आप डॉलर्स में, द मोमेंट यू पुट इन डॉलर्स यू विल फॉल इन सूट।
ओके सर,
ठीक है,
ओके, थैंक यू वेरी मच सर, थैंक यू।
So Ms. Dipti, we are done with all the questions as of now. In case anybody has any other questions, they can ask.
Yeah, they can ask in chat. Neel, you can start, sir.
Yeah.
Participant puts the question in chat box, so we can take as the presentation is on. Thank you.
Yeah. So moving forward, another section in which there was a major amendment took place is section 7, is regarding transfer of foreign contribution. So first of all, let us understand what was the before scenario, that section 7 was allowing the foreign source or NGOs to transfer their fund or re-grant their fund to a small NGO or any other section 8 company which is not capable of raising a big fund from the foreigners. They can transfer to another NGO which has already registration or a prior permission. That was possible before amendment. But after this amendment, the ministry is very clear that you cannot transfer a single amount to any person, irrespective which register as an NGO under the Ministry of Home Affairs. It has a long-term registration or not, doesn't matter. You cannot transfer any utilization from one bank account to another. So the re-granting, the sub-granting concept has been totally removed here. So what was the scenario before the amendment, that one NGO is a tie-up with another NGO and are running a project for the benefit of society. And due to this amendment, now the NGO which is big, which was transferring, re-granting the fund to a small NGO, but now they cannot re-grant the funds to the small NGO. So the project here gets on hold. That is a lot of issue that came. The matter goes in Supreme Court also. But the Supreme Court gave a one sentence judgment that it is not a fundamental right of the person to receive the foreign contribution. That is not a fundamental right. That was the main verdict of the Supreme Court. That's why the section is still there, that you cannot transfer foreign contribution to any person. Before that, it was allowed with the prior approval also, and to the person who is registered also under that. But now it is not allowed in any case.
Because
There's a major
before
amendment.
that, things were, it was, money was siphoned that route. They want to block that. That is the only purpose. There is nothing else.
But sir, I would must say here, due to the at the cost of the some notorious NGOs or malpractices, the NGOs which were really good and doing a good activity, they have to face also because of this amendment.
It's like, but it is like that, broking company in industry and other industry. Now, if you are taking foreign contribution, you should be big enough to ensure compliance, ensure the vigilance and all that way. The compliance cost of the NGO is going to be different. As I am telling earlier also, we had a topic. This CSR is a big industry now in India. It's an industry and it has its own compliance level, its own professional, and it's just at starting stage and it will move so fast. And that's why one has to be ready. Again, I'm telling, the NGOs are taking public fund without any refund. Of course, they will be double checked and they will be cross checked thrice. So that is happening now. So we have to accept that it is going to happen. Okay.
You see, just before the pandemic started, I think if I remember somewhere in 2020, September, October, November or something like that, almost about more than about 1,200 NGOs renewal was not done at all. They never applied. In fact, MHA issued a circular saying that these all NGOs are actually licenses cancelled. Then the matter actually came up.
Now the scene will further change with the social stock exchange. We are going to take that topic also, which is also going to be very interesting. But meanwhile, just go ahead. Sorry.
Yeah.
So now it is very clear after this amendment that NGO cannot transfer any fund from the utilization account to another NGO, irrespective it is registered with the ministry or not. Moving forward, there are some compliance that need to be done on a compulsory basis. The most important compliance is annual return. So NGO need to file annual return online in a specific form FC4. With that annual return, it need to attach balance sheet, audited balance sheet, statement of receipt and payments that is certified by the CE. Even there is no receipt of any foreign contribution, or there is no utilization of foreign contribution during the year, then also still NGO need to file annual return also. But in return, there is no requirement to attach the audited balance sheet or a statement of accounts which is certified by CE. But still NGO need to file an return also. Due date, it is from the end of financial year, within 9 months from the end of financial year, that is 31st December. So in any circumstance, government is not allowing any extension in this. So it is the utmost, I will say, compliance requirement that need to be done in due time.
Neel, I'm sorry, but point number 3 आपने जो बोला ना कि certificate of chartered accountant and audited statements is not required. My experience says that still the chartered accountant certificate is required, and the certificate from chief functionary is also required, which is not written here, as a zero collection of that year. Because this is my experience, because
I think, sir,
department doesn't allow you to submit unless you upload all these documents. The small things like stamp in a scanned manner and a signature of a chief functionary in a scanned manner, all this also needs to be required. And a bank statement copy is also required to be uploaded in normal scenarios. But still all these documents will be required as per my experience.
I think,
because
sir,
it will not allow you to submit your filings.
I think, sir, you are right, but I think this is before the amendment. In the nil return also, government is, I think, in 2019, in a month of November, if I'm not wrong, have changed this scenario. In nil return also, the CA certificate was required for the amendment, but I think the effective date is the 2021, and I think from this year, if you file this return, then there may your return get uploaded without this CA certification. I think so.
So
I'm not
this
sure.
Year I have not encountered this. I have encountered in the past.
Yeah. Okay. Yeah, that is true. So apart from this annual disclosures, there are other requirements that need to be keep in mind. So first of all, NGO should have its own website. That is a compulsory requirement. They should have a functional website of their own, and they need to place their audited statement, accounts, and all the receipt and payment for every financial year. Again, the due date is same within the 9 months from the end of financial year, that is 31st December. So due date for annual return FC4, it is the same. Along with that, you need to also disclose the same on a website. So you should have a functional website. And apart from the annual return, you need to file a quarter return also. If you have received any foreign contribution during that quarter, within 15 days, you need to file this. This is also important compliance that need to be done. There are some event-based filings also that if your NGO's name get changed or any address get changed, some objects in in the NGO need to change their object, the field of activity, then they need to intimate the ministry within 15 days also. There is a self-certified forms. There is a form changing name address FC6A. And for aims object, there is a form FC6B. This need to be filed within 15 days from the event date. And as I said, if there is some change in the utilization account, you are opening another utilization account or closing the account, then you need to intimate the ministry in form FC6D within 15 days of such change with the certificate from the banker. Now the fourth point is change in composition of governing body. So as per recent amendment, if any person or member of the governing body or the board of directors, get changed, this should be intimated to the ministry in FC60 form within 15 days of the change. Before this amendment came, there was a provision that if there is a majority of directors, the body gets changed more than 50%, then only the intimation need to be submitted. But now, if any change, whether it is a single director, resign or a new director appointed, then also need to be intimated in FC60 within 15 days. So before the filing DR12 under Companies Act, you need to file this FC60 to the Ministry of Home Affairs. But the due date is 15 days. There are some reportings from the end of banks also. The bank also need to report to the ministry if they receive any foreign funding in that account within 48 hours in respect of any utilization of account. Some basic details they need to intimate with this reporting, like from whom the foreign contribution has been received, the name of donor, the account number in which the foreign funding has been received, the type of funding, it is a local funding, foreign funding, it should be intimated, Indian rupees, in foreign rupees. These are some basic details that need to be keep in mind by the banks also. This was previously, I think, a 30 days timeline, but this due to this amendment now it is within 48 hours. They have to intimate to the ministry. The ministry is keeping a stricter vigilance over this field now.
And it's auto reporting actually.
Yes. Then comes section 16. It is very important section. Renewal of registration. So as I already discussed, for the long-term registration, it is valid for 5 years from date of issue. So, the NGO need to check this due date. They need to compulsory register or renew the registration. Otherwise, all the assets that is created from foreign contribution, it will be transferred to that ministry, and you need to apply freshly. So the due date of renewal, as per section 16, every person who has been granted certificate of registration need to renew their certificate within 6 months before expiry of certificate. Say my certificate is expiring on 31st December 2022. So I need to apply at least by from 1st of July, between 1st of July to 31st December. This is the timeline. Within 6 months before the expiry of the certificate. Some of the basic documents are same as you have already submitted in the application, like Darpan ID, signature of chief functionary, your registration certificate, constitutional documents, MOS, AOS, and a fee of 5,000 is to be paid to payment gateway. So now what happened if I miss my due date for renewal? So I think there is a very big NGO or missions of charity that is co-founded by Mother Teresa. It has also missed this renewal of certificate, and government have cancelled that certificate. And there was a lot of debate also. And now the NGOs is still applied for and got the registration. So it's a crucial part you need to keep in mind due date when your certificate of registration is getting expired, and you need to renew within 6 months before expiry in a form 3C. Now, central government has power also to suspend your registration if there is some non-compliance, cancellation also they can do, and surrender of registration. So let's talk about first suspension. Section 13 gives power to central government to suspend the certificate of the NGO for any reason, as mentioned in section 14. Section 14 deals with cancellation on the following grounds. If the central found that your application, whatever the details are mentioned, it was incorrect, false, or you have breached the terms and conditions of the certificate of registration, or if it is necessary also, if you violate any provision of that, or it is in public interest, it is necessary to do, they can cancel the certificate also and suspend also. And it is important, the fifth ground, that the holder of certificate has not been engaged in the reasonable activity for a consecutive period of 2 years, or the project has become defunct. Then also the ministry has power to suspend your registration. The suspension can be done for maximum 180 days, but with this Fcra amendment, it is extended for further 180 days. So government can suspend your registration for 180 days plus 180 days. So total 360 days. There's a new amendment. So there is a case. The minister has recently suspended the registration of a well-known NGO, Commonwealth Human Rights Initiatives, in short SHRI, for a period of 180 days and further 180 days. SHRI filed an application petition in the Delhi High Court that we have not received any show cause notice. We are not given opportunity of being heard without any notice how they can suspend our registration. So High Court said that the ministry has discretionary power under Section 13 to do in public interest, or if it's satisfied, it's necessary to do. There's no such clause or provision which mandate the central government that they need to give intimation or show cause notice before suspending the registration. So key reasons was that because they have not filed the annual return, or they have not fully disclosed in the annual return the details of project, the foreign contribution they have received. So the main conclusion of this case of this SHRI, it is not obligation on the part of government to give a show cause notice before suspending a registration. If they deem fit, if it's satisfied after due inquiry, they can do so for 180 days plus 180 days. So government is very strict in this area. Now consequences if my registration certificate gets suspended. So what will be the scenario if my projects, my hospitals, my schools? So if your registration gets suspended, then you cannot receive, or not eligible to receive any foreign funding during the period of suspension, unless government in case-to-case basis it approve also. It is a discretionary on the part of government. They can allow to receive foreign contribution, but you need to go for the approval route. And you cannot utilize the unutilized amount in your custody during the suspension period. And if you want to utilize the unutilized amount, you need to take prior approval of central government. And with the prior approval of central government also, you can only use 25% of the unutilized amount with the prior approval. Remaining 75% can be utilized only after your revocation of suspension gets done. So this is also very strict area. Government is not allowing to receive any foreign funding during suspension. You cannot utilize also unless you get the approval. And also with that, you can only utilize 25%. Remaining 70% you will get only after your suspension gets cancelled. Now section 14, cancellation of certificate. Yes, government can cancel the certificate as already discussed on the same grounds. If you are not complying, or in the public interest, it is necessary to do. Here government will give you a show cause notice before cancelling, because it is the supreme stage. In suspension, government has discretion to give or not, but in cancellation, before cancelling, it will give opportunity of being heard. Government has recently canceled the license of over more than 20,000 NGOs in the recent years. Mainly the reason is due to non-filing annual returns and other disclosures required. So what happens once your certificate gets cancelled? Then there is a cooling period of 3 years that NGO cannot apply until the 3 years get expired from the cancellation. So once your certificate cancelled, then you need to wait for 3 years for applying afresh. And any unutilized amount in your account or any assets created out of foreign contribution, that will be in the custody of the ministry. If you are applying, there is a provision which enable you. If you are applying afresh after 3 years, then government will give you this unutilized amount and the foreign contribution and assets also. But you need to wait for 3 years at least. Any question?
Neel, just in the sense that if it is suppose for this registration is cancelled for the receiving foreign contribution, right? But otherwise it's valid.
No, ma'am.
From India?
Sorry.
Any contribution from India they can receive?
That you can receive, but you cannot mix that contribution for the project which has been also cancelled. Yeah. That is a separate. You can operate your Indian operation, that is no issue, but you cannot mix this local funding with the foreign funding in the project. That has been also cancelled. Say I'm running a hospital, right? And my certificate get cancelled. So here what happens, your hospital will not close because it is you are established for the years. So it will goes to in the custody of the ministry. If they think fit, they will also continue the operations of hospital, and they can also utilize the unutilized amount from the bank account. And if you applying afresh within after 3 years, and if they think it is okay, now it is necessary that they have compared with all the provisions, they have rectified with all the mistakes, and may transfer this hospital and the custody of assets to you.
So, but Mr. Ashish, have you gone through this situation that gone through in the sense having knowledge that an organization whose Fcra this registration is cancelled, but they can continue their operations with the Indian contribution, right?
They can do that.
Yeah, as rightly Neel said that they will confiscate all the assets which have been obtained from the
foreign country.
Foreign contribution.
Yeah, but balance that you can carry out.
Yeah, that is right.
The bar is on the receiving foreign contribution and whatever the assets generated out of foreign contribution. For Indian assets, that there is no bar from the ministry. That is possible.
So in your annual filing, your assets in terms of movable and immovable are clearly mentioned. Okay, so there is no issues in terms of identification of those assets. So as Neel rightly mentioned, it has to be considered that.
So moving forward, there is a new section which has been introduced in the Fcra 2020, which enables any NGO which want to surrender its certificate for any personal reason. So section 14 is a section that allow the NGO to foreclose its Fcra registration due to any reason. There is a form FC7, but government will do utmost due diligence and scrutiny before allowing the surrender of certificate. So it is a newly section, and any NGO which want to surrender certificate due to any reason, they can apply. Whatever the assets, again same, the foreign contribution utilized in the FC account and all the assets, that is will be based in the authority of the central government. Any question, any doubts?
You can visit the chat box if there are any questions.
No, I think nothing is there.
Nothing is there. Okay. Any participants like to ask any questions at this stage? We can address.
Just now it is there. Private limited is wholly owned subsidiary of a foreign company and has formed a Section 8 company to carry out CSR activity.
This has been already, I think, answer is given.
Okay. You go ahead.
And from my side, it is done. If any question, then I can answer it. Any question, any doubts?
Mr. Ashish, your number is required. Please put it on the chat box.
Okay, okay.
We'll share with you also if required, all the participants, but yes, if they have requested, please put it.
See, there is one question has come. Can investment can be made in a debt-dominated mutual fund?
Yes, sir. I already answered this. any investment that is linked to market forces.
Speculative.
Yeah, whether it's mutual fund or any equity share, that is not possible. But for investing in a non-that secure investment, that is secure by any asset, that is government storage and gold bonds or anything, that is possible. In that is safe. You can invest. At any fund is highly appreciated, depreciated of risk. That's very fluctuation kind of like share market. That is not possible. And also I would mention any interest generated from the foreign contribution. When your money is lying in the bank account, right? Any interest generated, other income generated from that foreign contribution, it is still be considered as foreign contribution, and you need to disclose in the annual return also.
There's another question is there. A private limited is a wholly owned subsidiary of a foreign company, which has formed a Section 8 company to carry out CSR activities. Is it essential for this Section 8 company to obtain FCRA registration before accepting the donation?
Sir, it is a separate entity in a Section 8 company, right? Although the major control is from the ultimate holding company, parent company situated in foreign. Correct? But it is for a private company. I think FDI limit is 100% allowed in almost majority of sectors. So we need to check the sector cap for this. But I think for private company, there's 100% of the paid up capital they can receive FDI. So I don't think so. It will fall under IM category. It will not be treated as foreign source or foreign contribution.
Okay. That's
So
all.
we have one more question from Mr. Gopal Yad.
Right.
So Mr. Gopal, are you there? If you are there, please unmute. Question says,
Sir, Professor, sir, I have just answered my question. Thanks for the panelists.
Okay.
My further question to you, considering that this Section 8 is a subsidiary of the private limited, A private limited. Since A private limited is receiving foreign funds as its equity, would that have any impact on the Section 8 company for accepting the donation from A private limited?
See, I read out your question. I think your voice is not clear. I'll read out your question. Private limited is a WOS of foreign company and has formed a Section 8 company to carry out CSR activities.
No, he's asking a different question. That question has been answered.
Okay.
He's asking a different question. He says there is a private limited company is there, and it has got a subsidiary
Section 8.
Section 8 company.
Correct.
And a private limited company gives you donation to Section 8 company.
Correct.
Is that correct, Gopal?
Yes.
Yeah. So he is asking in that context whether FCA is required, because a company that is receiving a what you call equity capital from the foreign company.
Correct.
But I think equity capital, if you are receiving FCRA, is not called for. And if the A company is giving to Section 8 company, it will become a local source. It is not a foreign source.
Okay,
no, sir, there is an amendment recently happened. Earlier, it was like if your parent company, the Indian company which they have established, the parent company has more than 50% holding in the Indian company, which is registered under ROC, will be considered as a foreign entity or a foreign subsidiary of the parent company. So FCRA was applied. Now there are some amendments. Neel, you can just take them to that particular slide where the percentage ratio has been removed, and now if the Indian registered company is giving a donation to the Section 8 company or an NGO, then you do not need a FCRA registration.
Okay, fine. Thank you.
So Neel, can you just read out for the interest of everybody?
Yeah. So there is a very basic doubt. Suppose my company name is ABC Limited. I am an Indian company, a private limited company, and my parent company is situated in USA. I am 100% wholly subsidy of my parent company. I am receiving some funds from my parent company, right? And now I have established a Section 8 company, and I am transferring the same funds to my Section 8 company for doing some CSR activity. So the question may arise whether it is considered foreign contribution. So whether I apply for FCR or not. So till this amendment came, your company will be considered as a foreign source. because the funding is directly received from the ultimate parent company. So it is a rounding of fund. But government has clarified that if this FDI limit, you are not breaching the FDI limit, your sectoral cap, then it will be treated as domestic funding. You need not to apply for the Fcra registration. That is very clearly mentioned in the FAQs also, in the clarification also. So, sir, your company will not be treated as a foreign contribution, and you need not to apply for the Fcra registration until you are breaching the FDI limit or going for approval.
I will interrupt here. Mr. Bala, our earlier topic of foreign company, we discussed this very much, whether wholly owned subsidiary will be or a subsidiary will be foreign company or not. And under the Companies Act, there is not, they have given exception, and we were of the view that it will not be, because that foreign company compliance need not be done by subsidiary, though specific clarification is required. But here they have already made it that a subsidiary of foreign holding company will not be treated as foreign company for the purpose of FCRA. So again, we also discussed that when we are filing consolidated account with the company MCA, they are not raising the question about foreign company compliance. So I think our conclusion is correct. Holding subsidiary, which is a holding company having foreign company, is not foreign company within the meaning of Companies Act.
Correct.
Okay, thank you. Any other questions? I think
Chat box, we answered everything.
we answered everything.
Unless some participants have some more, we can take. Otherwise, we can call it a day.
Yeah. I think we'll close it. At close, I will thank all the questionnaires, especially Nimita, Namita, Nitin, Mr. Sanket, Satish, Sumit, Musharat, Srikant, Anita, and Mr. Virat, Sweta, and Mr. Satish. Thanks for attending. All participants for being active. Mr. Ashish, you have been given a lot of questions, so your requirement of raising question did not come. Our participants were quite active.
Yes, very much.
And thanks for all your knowledge sharing, contribution, and experience sharing. It was wonderful knowledge sharing by you. Neel, it was wonderful presentation, because you were answering the question which was not in presentation also. That's wonderful. That shows your readiness to answer the question. As usual, Mr. Bala, your briefing was superb. Thanks everyone. Thanks for your participation. Mr. Ashish, you would like to say some few words for on this?
No.
Ashish,
When the audience is
I'm very thankful to you, because there are a lot of things which I added to my knowledge today.
Yeah.
Your practical experience, we could learn a lot of things. So I must be personally thankful to you on my own behalf and also on the behalf of the audience.
no.
Neel has done
It's my pleasure to share the
extremely a
experience.
good homework. Nice presentation. He has covered almost all the things. Good job done, Neel.
Good job,
Thumbs
Neel.
up to you.
Yeah, Mr. Ashish, you wanted to say something, please?
No, I'm just thankful to you, Ms. Dipti, to give me the opportunity to, just back with the audience and give me a platform to share my experiences. So thanks to everyone, and thanks Neel for the wonderful presentation. Mr. Bala, thank you for supporting, and you have been a wonderful coordinator for this project. Thank you.
Thanks everyone.
Thanks everyone.
Have a good Sunday.
Thanks a lot,
Bye.
everybody. Take care. Stay healthy. Stay safe.